is locked.
Kimberly Parks on behalf of plaintiff, Your Honor.
Good morning, Your Honor. Janice Luck here, and I have my friend of 18 years, Odile Huguenot-Haber, who is offered to co-sign for me on renting an apartment so that I could hopefully, I'm asking that I move out June 31st. That would give me time to finish up filing other papers. I spoke with United Way yesterday in person, and they will help me with my taxes next Wednesday.
Okay. I got you.
Received an amendment at 6:22 p.m. last night from Attorney Parks requesting money. I'm owed money. I'm owed money from the Humeskis, but I also wanted to let the court know that I paid $165.37 in February. $470.37.
Ma'am, I'm not going to be able to read that.
So $470.37 was for the electric bill, which was on the kitchen table when she was in the hospital. And there was an email that came in from Miamic saying a payment reminder on the home insurance that needed to be paid or it would be canceled. So I paid the minimum on that, which was $495. The two totals together is $965.37. The water utility that they're requesting for February 16, 2023 is Oscar's bill. That's not my water.
I see the amended complaint. There would need to be an answer filed to it.
What?
But you're willing to move out?
Yes, I want to move.
At the end of June?
Yes.
This defense opening hits like a sledgehammer. He's not tiptoeing around reasonable doubt. He's going straight for the throat, calling the allegations a flat-out lie. One by one, he dismantles the prosecution's case. No police. Contact, no DNA, no witnesses. Then he drops that knockout line. Either it's a lie, or he's the luckiest man on the planet. That's the kind of statement that sticks in a jury's head from start to finish.
Since March.
Your Honor,
I've been taking care of his mother for 6 years.
That doesn't matter.
7 for minimum wage.
Your Honor, we would reject that offer.
Okay. So you want me just to set this for trial? Because here's what's going to happen, counsel. So before you reject that offer, if I set this for trial, I'll just set it for trial on everything. You guys will have to come in on the 16th. Let's say you get a verdict. You get a verdict saying that she's got to move out. Best you're going to get is the 26th. If she asked me for a few more days, I'd give it to her. So it's going to be the end of the month anyway. But you guys can reject the offer. I'll just set it for trial.
If we would agree to that, if you would agree that the writ will issue immediately if she is not out by the 31st.
I don't know where this became a negotiation. Here's what's going to happen. There's going to be a judgment today for possession. The writ date would be June 30th, or that she'd have till June 30th. And then it would work that way. I'm not agreeing to anything. We can either do this or I can set it for trial. Which do you guys want to do?
This isn't a full-blown trial. It's a bond violation hearing. The bar here is way lower than beyond a reasonable doubt. The judge just has to decide if it's more likely than not that the defendant broke those bond terms. That means the defense is fiery, no DNA. No witness's argument might sound great for a jury, but it doesn't carry the same weight in this setting.
Due and owing, Mr. Mann.
Your Honor, my client's books and records indicate a current balance of $1,839.40. Costs are $155. So the total possession judgment that we would be requesting would be in the amount of $1,994.40. My notes indicate that Ms. Feitz was not present at the first hearing.
That is correct. Ms. Feitz?
Yes.
Um,
Currently, right now, I'm homeless. I'm jobless. I have to turn my car over to the bank. I had a job of 23 years due to the automotive industry. I lost my current job. And my dad turned sick. I lost half of my stuff. I was storing it at a friend's house. It got thrown away. I am stranded in Kentucky. currently right now trying to take care of my father. I don't have a home and I'm not working currently right now. I'm trying to get money to get back to Michigan so that I can try to make arrangements to make payments. I'm not sure what the amount is
Okay.
due for.
Okay. All right. Ms. Fights, you got a lot going on, right?
I have a lot.
All right. Take a deep breath. Okay. So if you lose, I just want to make sure I understand. If you lose this home, you're not going to have a home to come back.
That shift in tone is jarring. The defense came in like a wrecking ball, tearing into the state's evidence, but the prosecution pivots to pure urgency and danger. This isn't just about what happened, it's about what could happen next. The detail about the victim's location being known but not disclosed in open court hits hard. That's not theatrics. That's a real-time safety measure. It turns the hearing from a procedural debate into something that feels immediate and high-stakes.
Wish she wouldn't leave, and I said I can't afford to live there. And I told her I was giving her the trailer back because I can't afford to live there. And I had to move out as much as I could by myself. And then I had stuff stored at a friend's house and it got thrown away. So I don't even have half of my personal stuff.
Ma'am, let me ask you this before the judge jumps in, at the risk of interrupting him for a moment. Did you sign off on the title?
I don't have the title. It got thrown away when I moved. I was trying to find my title to my trailer when I was trying to pack my stuff up. And I was storing it at a friend's house in a shed, and half of my stuff got thrown away.
So that, I think, is the issue, Your Honor, is that the title has been signed over.
Well, let me ask you this, and I'm just trying to figure out, Ms. Wright, is your plan to come back to Michigan to this trailer, or what do you intend on doing?
No,
what do you want to do?
I can't afford to live there. It's too expensive.
Okay.
Because I don't have a job right now. I was working at a job for 23 years and I lost it. And before I lost it, all my overtime went away and I wasn't even working 40 hours a week. So I was struggling making my payment every month there for about 4 months. And then it just came to the point that I couldn't afford it. So I called Annette at the end of February and told her that April 1st, I will be out of the trailer because I can't afford to live there anymore. And then as I was moving my stuff out, I got the call that my dad had a heart attack and I dropped my stuff and left and went to Kentucky. And now
This is the kind of moment where the whole room feels the temperature rise. The defense's casual "we were coming today" isn't just a weak excuse, it's practically an open invitation for the judge's wrath. When a judge's tone changes like that, it's not just about one missed deadline. It's about the message it sends that court orders can be ignored until it's convenient. In that instant, the hearing stops being routine and turns into a personal rebuke, and the defense attorney is squarely in the hot seat.
All right. Here's what I'd like to do. I'd like to do this in a way that she doesn't have a judgment, so that when she goes to seek other housing, there isn't something on her record. So she's probably likely going to need ultimately to sign over a title, but she can certainly, possession, she's just out of the premises. So here's what we'll do. I'm going to indicate in the file there's just a voluntary surrender of the premises. Surrender of tenancy, I guess we're going to have to put it that way.
Okay.
So that they can secure the trailer.
Okay.
The legal battle completely shifts gears. The attorney's apology might sound sincere, but sincerity doesn't erase the fact that the judge now sees this as a breach of the court's authority. When a judge uses the word sanctionable, it's not just legal jargon. It's a flashing warning sign that the consequences could extend beyond the current case. The defense's credibility is damaged. The client's chances at keeping bond are evaporating, and the focus is no longer on the evidence at all. At this point, the issue isn't what happened. It's whether the court can trust anything coming from the defense side ever again.